Hello, everyone. I'm Derek Teeter, a partner in Husch Blackwell's Higher Education Group, and thank you for joining our program today. Before I begin, I'd like to cover just a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We will try to answer some of them, but there's a lot to cover and we have limited time. Given the high number of attendees that we have, it's probably unlikely that we'll be able to follow up by email, but we'll do our best. A PDF of the presentation is available in the program materials folder, along with our presenter biographies. And toward the end of the program, please be sure to complete a short survey. We do look at your feedback and we use it to plan future programs and to meet your business needs. Okay, that's all for the housekeeping items, and we have a lot to cover, so let's dive in. First, let me introduce our speakers today. I'm a partner in the Higher Education Group. I'm joined by multiple colleagues, John Borkowski, Annie Cartwright, Julie Maselli, Lisa Parker, Alex Rushing, and Elizabeth Samples. We are going to present in sequence, and each one of us can just tell you briefly about ourselves as we get to our area of expertise. We are going to cover multiple different subject matters today. It's been a fast and furious last 10 days or so, and we're really trying to highlight areas that we think are of notable interest and potential significant change with the new administration. So I'm going to start us off with free expression, and we will close with a leadership and policy forecast and cover all the different topics in between. Okay, so I'm up as our presenter on free expression, which is really a broader phrase that captures not just freedom of speech, but all different types of expressive activities. This was obviously a significant issue in the last presidential campaign, and it's an area of emphasis for this administration. And we think there are going to be multiple facets to this increased emphasis on the First Amendment, free speech, freedom of expression. First, one of the primary ways that the First Amendment is enforced is when individual litigants file federal lawsuits against state actors. Those are public universities, community colleges, maybe public technical schools. We expect to see a continued increase in the number of such lawsuits. We expect there to be increased attention by law firms and public interest firms finding public institutions that have some alleged infringement of free speech rights, and a greater willingness to litigate those issues in light of where this administration has placed priorities. Of course, private colleges, private universities are not, strictly speaking, governed by the First Amendment, but many of you have free speech policies, or you've made statements about freedom of speech or expression in your student handbooks. And claims can be brought under a breach of contract if you violate the policies and standards you've articulated to your students or to your employees. And we also expect an uptick in those types of cases as well. Now, perhaps one area where the administration itself is most likely to be involved is that the Department of Justice often will involve itself in private lawsuits by filing amicus briefs in support of one party or the other. It seems likely to us that the Department of Justice is going to be much more willing in this administration to file amicus briefs in support of private plaintiffs who are suing institutions and alleging violations of their free speech rights, especially if those cases are characterized as ones involving censorship on subject matters that this administration also is focused on, things like gender identity, anti-Semitism, etc. The Department of Education will likely issue sub-regulatory guidance. That's a fancy word for Dear Colleague letters, helping public institutions understand the parameters of the First Amendment and freedom of speech and the demarcation between those rights and what would constitute prohibited verbal or written harassment. We also expect the Department of Education will issue sub-regulatory guidance just broadly encouraging even private institutions to make greater space for freedom of expression. At the moment, your Title IV funds, your eligibility for financial aid support is not strictly tied to compliance with free speech. It is strongly encouraged, and it's the sense of Congress that all schools receiving federal funds should respect the First Amendment and free speech rights. There have been in the last several years initiatives in Congress to explicitly tie eligibility for participation in Title IV to compliance with First Amendment and free expression principles. And that is a potential change that we might see introduced in Congress, probably not immediately, but perhaps at some point in the next couple of years. And that would then provide a significant leverage tool or stick, you might say, for the Department of Education to enforce compliance with its broad view of freedom of speech. The last facet we anticipate being an issue as well is that the federal government has tremendous influence and pressure that it can bring to bear on accrediting agencies. And those accreditors in turn have expectations for schools with regard to certain policies, including policies governing freedom of speech and expression. And so this sort of broad support of free speech and expression is going to come from the department, be pushed down through the accreditors, and make its way into the way that accreditors interact with various institutions. Not just specific policies, but also perhaps complaints from students made to accreditors about whether or not you are abiding by your policies and standards. So these First Amendment issues are going to come in lots of different ways and be a significant legal issue that we will navigate in the next 3 or 4 years. I said before that we anticipate an intersection between free speech rights and certain subject matter areas that are also points of political emphasis for this administration. And think about these are maybe the types of cases, the types of factual scenarios where we are most likely to see First Amendment litigation, or we are most likely to see the Department of Justice filing an amicus brief. Preferred name and pronoun policies and similar directives are likely to be, in some ways already have been for the last year, a significant fact pattern where faculty or students assert they have a First Amendment right not to be required to use certain preferred names or pronouns as policy may dictate. We obviously have had a lot of physical protests and encampments on campuses in the last 18 months. There is a First Amendment aspect to those protests. Protesting is freedom of expression. But this administration also has a very strong view that anti-Semitism should not be tolerated. And so we're likely to see political involvement in cases that involve sort of the intersection of campus protests, physical encampments, issues involving foreign policy, and the like. A third subject matter area, the idea of the heckler's veto and controversial speakers. So the heckler's veto is when we have a group of individuals who don't want to hear a controversial message, and so they might come in and try to block access, let's say, to an auditorium or disrupt the ability of a guest speaker to deliver their message. And generally speaking, the courts have said schools have to prevent heckler's vetoes, because if they weren't prevented, then controversial speakers would never have the ability to speak. This administration takes the view that heckler's vetoes should not be allowed and is likely to take that position in litigation. Student academic freedom, the rights of students themselves, not just faculty, to articulate political views, to not be punished in how they're graded because of their political views, may be something we see. There will be an intersection of First Amendment free expression rights and religious expression, and the ability of religious student organizations to speak collectively and not have their messages regulated by public administration. Also an area where we anticipate a great deal of litigation and probably the Department of Justice becoming involved as an amici in the lawsuits. And then anti-Semitism, anti-Israeli campus protests related to Gaza. This will probably not be quite as prominent as it was in the last 12 months, but continues to be an issue and a point of emphasis for this administration's Department of Education as well, we anticipate. Okay, so with that, I need to quickly move us on to our next subject matter, which is civil rights, and I will pass our baton to my colleague, Elizabeth Samples.
Thank you, Derek. My name is Elizabeth Samples. I'm a partner in our group, and I spend a good deal of my practice focused on areas of civil rights compliance and advising our institutions. So I'm going to talk about that aspect. I'm going to begin, though, with a few points related to the U.S. Department of Education, and some others will comment on department activities later as well. Broadly speaking, President Trump has referenced elimination of the Federal Department of Education in remarks, and there have been some references to potential policy and legislative plans for the Department of Education, including moving offices to other agencies. We don't know at this point whether there will be administrative actions or congressional approval to make changes such as these, but they have been referenced. With respect to department appointees, though, we wanted to flag that senior appointees to the department have recently been announced on January 23rd, including a Deputy Assistant Secretary for Policy and the Office for Civil Rights. And then finally, related to executive orders regarding DEI programs, John's going to talk about that a bit more in a few minutes. But the Department of Education has removed guidance documents and other documents referring to DEI from the website, and has placed employees charged with leading DEI initiatives on paid administrative leave. With that, I'm going to move to our Title IX update. I'll begin the Title IX update with ED's 2024 Title IX final rule. As background, as I'm sure many of you know, ED released proposed regs in June of 2022 and then published a final rule in April of 2024. There were notable changes, including the scope of coverage to include various forms of sex discrimination under Title IX, including sexual orientation, gender identity, sex stereotypes, and sex characteristics. There were also changes to the definition of hostile environment sexual harassment, and an allowance for the use of a single investigator model with certain parameters. Implementation of these regulations was then enjoined in over half of the states and at hundreds of institutions. So many anticipated a return to the 2020 regulations following these injunctions, and now a district court decision has vacated ED's 2024 Title IX final rule nationwide. The court ruled that expansion of on the basis of sex to include discrimination beyond discrimination on the basis of being male or female exceeded ED's authority, and the court differentiated from Bostock, saying that the case was limited to Title VII and was an improper basis for changes to the Title IX regs. So the result is essentially that institutions will be reverting to previous policies which complied with the 2020 Title IX regulations. When doing so, institutions should be sure to update their definition of sexual assault to align with the changed FBI's National Incident-Based Reporting System definition. And in addition, many states and cities have passed laws in recent years regulating the subject of gender identity discrimination and harassment. And these laws may create additional requirements, even though the 2024 Title IX regulations are no longer in effect. The administration has also expressed its position regarding the definition of sex. A January 20th executive order includes definitions of sex and gender identity that will govern executive interpretation and administration policy, and define sex as biological classification as either male or female. The executive order also rescinds guidance documents from the Attorney General, DOJ, Department of Ed, HHS, and EEOC regarding LGBTQI+ harassment. There are a wide range of cases being litigated across the country about whether Title IX applies to biological sex only or includes gender identity. So this administration has asserted its position on this question, so that will likely affect cases in which the government is a party. And ultimately, we may see resolution on this question from the Supreme Court. And then yesterday, OCR announced an investigation into the Denver Public School District for discriminating against its female students by converting a female restroom into an all-gender restroom in one of the district's high schools. This is perhaps an indication of enforcement priorities for OCR, at least initially, and you can read the statement about the investigation on the website. And then finally, on January 16th, OCR issued a fact sheet on its interpretation of Title IX equity in athletics requirements and the application of those requirements to name, image, and likeness activities. The fact sheet said a school may violate Title IX if the school fails to provide equivalent benefits, opportunities, and treatment in the components of a school's athletic program that relate to NIL activities, and identified the areas of publicity and support services. It also included an interpretation that athletic financial assistance includes compensation from schools for the use of students' NIL. And that when a school provides compensation in this way, it must be made proportionally to male and female athletes. The fact sheet acknowledged a distinction with third-party compensation for NIL and said that the fact sheet doesn't offer specific guidance on Title IX's application to third-party payments, but it also said that it's possible that NIL agreements between student athletes and third parties will create disparities that trigger a school's Title IX obligations. So this guidance was released at the very end of the prior administration, so we'll be tracking OCR's actions related to the guidance to see if it's rescinded or whether there will be subsequent guidance from the administration on this policy interpretation. And then lastly, before I turn it over to John, as far as ADA Section 504 enforcement and developments, there is a new rule on accessibility of web content, updating Title II of the ADA. This was published in the Federal Register on April 24th. Title II is applicable to our public institutions, and the new rule includes specific technical standards for web content, namely the Web Content Accessibility Guidelines. The rule includes requirements for compliance with that standard, with limited exceptions for archived content and some electronic documents and some issues related to social media posts. There's a specific timeline for compliance based on the size of the state or local government. And for purposes of the rule, public institutions are considered to serve the entire state in which they're located. And for those entities serving 50,000 or more persons, the compliance date is April 24th, 2026. Beyond that, there has not been much discussed in the way of policy or regulatory action under ADA or Section 504, so it's uncertain how issues of disability rights will be included in policy agendas. During the prior Trump administration, the then pending regulations regarding accessibility of web content were put on inactive status. So based on that, we don't expect much in the way of expanded regulatory action related to digital accessibility. Also, there are some questions about enforcement under the ADA, given the current freeze on litigation in the Department of Justice Civil Rights Division, which was implemented as of last week. However, with limitations on enforcement actions, private suits and demands will continue under these statutes. And with that, I'm going to turn it over to John to discuss other civil rights issues, including under Title VI.
Thank you very much, Elizabeth. My name is John Borkowski, and I do all sorts of civil rights litigation for our education group, and also handle OCR investigations. One of the big areas of activity in the last couple of years, as Derek alluded to, has been Title VI enforcement, particularly around discrimination based on ancestry or shared ethnic characteristics, particularly around conflicts concerning the protest of Israeli activity in Gaza. Hopefully that will slow down some with the ceasefire, but we think that there will be a continued emphasis of on the effect of campus protests on Jewish and Israeli students. And as Derek highlighted there's going to be some tension between the emphasis on free expression on the one hand and sort of the strong support of this administration for Israel and Israeli policy. So I think that's going to be interesting to see how that tension between the anti-discrimination provisions of Title VI and the emphasis on rights of free expression play out. The Trump administration has been sort of quite adamant, going so far even as to sort of start laying the groundwork for potentially deporting foreign students who engage in anti-Israeli activism, and whether that's viable in light of these other concerns that we're talking about will be really, really interesting to see. In this Title VI space also, I just wanted to highlight briefly that there was some discussion in Project 2025 about removing the disparate impact standard from Title VI regulations and guidance. That would, of course, take activity from the Department of Education. And it's just too early to tell whether there's going to be follow through on that or not, but that's something to keep an eye on. Of course, this week there's been a high profile emphasis on the executive orders eliminating diversity, equity, and inclusion programs in federal programs. There's also been in the executive order sort of a push for federal government employees to seek out and look for informal DE&I activities and report on colleagues who are involved in those. And again, there's some tension there, I think, between really pushing a substantive agenda in one area and then the free expression concerns in the end. So I think some of that is likely to end up in litigation. More important, I think, for our purposes in the higher education world, is there's going to be increased scrutiny by all aspects of the federal government on DE&I programs in the private sector, and in state institutions as well, outside of the federal government. The administration has already announced that there's going to be investigations of major institutions, including corporations, but also colleges and universities, particularly with endowments over $1 billion. Hopefully, most of you are in good shape with respect to this because of the Harvard and North Carolina decisions. And in the recent years, sort of a lot of institutions have reviewed their programs on DE&I along with reviewing their admissions program. But if you haven't, I think it's really essential to do so soon, because these executive orders don't sort of outlaw DE&I programs, but they do indicate pretty clearly that the federal government under this administration is going to be looking to find illegal DE&I programs or illegal consideration of race, ethnicity, gender. And so you want to make sure that your house is in order. Just a couple notes on the Department of Justice. Elizabeth mentioned briefly that there was an announcement of a temporary pause in Civil Rights Division activity. The scope of that is unclear. I've got a couple cases in which the Department of Justice is involved where they have been following up folks in the Civil Rights Division, but they're on existing cases. So I'm expecting that this is going to really largely affect what sort of new cases are abroad and what cases that are under consideration get filed or not. And I think there's going to be a very big reversal in direction with respect to enforcement activities. I think obviously the administration is changing its view from under the Biden administration of DE&I. There'll be a change in focus, I think, and an increased emphasis on admissions and scholarship that consider race or gender. Clearly, as Elizabeth already mentioned, there's also going to be a different position on cases involving LGBTQ rights. Very quickly, these things are affecting the K-12 world too. There's going to be a lot of changes. I think there'll be more support for school choice initiatives at the federal level. There's discussion of changes in the school lunch program. I expect there will be a possible attempt through DOJ to try to wind up any remaining continuing desegregation consent decrees. And of course, a lot of folks in the K-12 world are also very, very concerned about the effect of immigration enforcement on their communities in the same way that higher education institutions are as well. And with that, I'll turn it over to my partner, Lisa Parker. Lisa.
Thank you, John. Hi, everyone. My name's Lisa Parker. I am a partner in our higher education practice. I focus on a lot of regulatory matters, including accreditation and other items. So we don't know a lot of things that are certain in terms of what's going to happen in the Trump administration, but we do know that one of the key focuses will be immigration. In particular, an emphasis on removing undocumented immigrants from our country. Right now in higher ed, we have about 400,000 students that are undocumented. Many of these students we refer to as dreamers. These are students who came to our country as children and have continued to be in our country, and they may be enrolled in your institution. Many of them are participants in the DACA program, the Deferred Action for Childhood Arrival. This is not a legal status or a pathway to citizenship, but it allows them to work in the country without fear of deportation for 2-year time periods that they can renew. Ever since DACA came into being under the Obama administration, it's had numerous legal challenges. These challenges continue and are ongoing, and right now DACA has been enjoined. But we do know that President Trump, under his prior administration in 2017, did try to end the DACA program. He then tried to limit it in 2020 as well. So the issue, or the question for us all, is whether or not he will rescind the DACA regulation. One thing of note, though, is that in December, he said that he did have compassion for the Dreamers, and so it is unclear what will happen with DACA. We also right now have more international students on our higher education campuses than we've ever had. And these students are under F1, M1, and J1 student visas. This allows them to temporarily be in our country so that they can study at our institutions. Currently, these visas remain valid, and we have not heard anything or seen any indications that these programs will stop. However, because of the Trump administration's past immigration policies, we may find that students feel uneasy coming to the United States to study. And also, because of the scrutiny on immigration, the time period to get these visas could take longer, and we could see a slowdown in these visa processes. Also, some of these students participate in optional practical training, which allows them to work in the STEM field. Again, we've not heard anything about this being impacted, but we could also see a change here. Finally, we have a lot of foreign faculty on our campuses who are working under H-1B or the O-1 working visas. Those visas allow them to work on our campuses due to their specialty in a variety of fields and their expertise. When Trump was in president before, he temporarily stopped the H-1B program, and we saw a decline in the amount of people who were able to maintain H-1B visas. It is unclear whether that will be the stance under this administration. Elon Musk is over the Department of Efficiency now, and he has indicated that he is a fan of the H-1B program. And recently, President Trump has said that he also looks favorably upon the program. So with respect to these classifications that we know have many people on our campuses uneasy, we are in a wait and watch and see mode. Another thing that we know is of great concern to all of you is what happens if there's an immigration enforcement action on your campus. And for that, I'm going to turn it to my partner, Alex Rushing.
Thank you, Lisa. Appreciate it. Hello, everyone. My name is Alex Rushing, and I'm a partner based in our St. Louis office, but work with higher education clients all across the country. I have been assisting our education clients on all sorts of student issues, but recently, immigration and student records issues has taken a big priority, especially since last week. In 2011 and again in 2021, Immigration and Customs Enforcement, commonly known as ICE, issued a policy guidance memorandum that generally prohibited ICE agents from engaging in enforcement actions at, quote, sensitive locations, which included schools, hospitals, and religious institutions. Enforcement actions include interviews, arrests, searches, inspections, and surveillance. As many of you know, and as you see on your screen, on January 20th of 2025, the Trump administration rescinded these sensitive location protections. So now that this has happened, we've been getting all sorts of inquiries from our higher education clients about how to navigate enforcement on their campuses. So let's break that down. First and foremost, there is no one-size-fits-all approach to this. What one public community college does in Illinois is likely very different than what a private four-year institution in Texas is required to do. You all know your campuses best, so make sure that whatever approaches you're considering regarding responding to immigration enforcement considers all of those community members, faculty, staff, students, etc. The focus should be on the importance of maintaining a safe and supportive educational environment and workplace, while ensuring compliance with legal obligations, of course. As part of that focus, you should consider developing policies, procedures, protocols, or practices regarding how your institution intends on responding to ICE inquiries, whether that be for student records, employee data, physical requests to enter campus, etc. We've seen a lot of success with clients having a clear internal communication plan for how information should flow in these instances and lessen any disruption to the campus community. This may include the fourth bullet that you see on your screen, which is designating a point of contact or designated representative for immigration enforcement activities. Any of the clients I work with on the webinar know I'm a firm believer that the fact that you have a great policy or protocol is wonderful, but has to go with training. So for those who are implementing those policies or protocols, please make sure they have been properly trained on what they should be doing, how they should notify a designated individual or individuals if ICE or law enforcement officers are present on campus, and then to refer such individuals to the designated representatives. Those designated representatives also need to be very well versed in the third bullet point in this section on your screen of understanding your institution's legal rights and responsibilities under federal and state law. So let's get into that. Since we're covering this slide for such a short period of time on this webinar, we're only going to focus on a handful of federal considerations, but many states have state-specific considerations that you need to be mindful of, and also very helpful guidance that was recently released since January 20th of last week that you and your counsel should review in preparing these protocols. Many states have gone about doing that guidance piece, so be sure to consider that if your state is one of those. Okay, so with that said, let's briefly talk about the federal law perspective. It's really important for higher education institutions to be mindful that ICE and other law enforcement agencies must still go through the judicial process to access a student and student information protected under FERPA. As you all know, FERPA requires institutions receiving federal financial assistance to protect the confidentiality of all personally identifiable information in a student's education records, such as emails, student files, etc. A couple nuances to keep in mind. An institution's police department records are generally not protected by FERPA because they are specifically excluded from the definition of education records. These records are likely not protected if they are created by the institution's police department, created for law enforcement purpose, and maintained by the institution's police department. Another exception to FERPA's protection is that FERPA does not protect F1 and M1 student visa records. Nonetheless, a subpoena or judicial warrant should still be presented to access any student records in private areas of the institution, such as administrative offices and faculty offices. The last piece I want to go over are some pieces of terminology that you all should be familiar with. We were actually just discussing this before the webinar started. First, a judicial warrant is one that's signed by a judge or a magistrate, which allows ICE to conduct any search as authorized in the warrant, including employee and student files. Although administrative warrants may be signed by an immigration judge, it's important to review the warrant to clarify if it is a judicial warrant or an administrative warrant, which I'll discuss in a second, because the institution's legal obligations are different depending on the type of warrant. An administrative warrant is very different from a judicial one in terms of the institution's obligations to comply. These warrants are issued by a federal agency, such as the U.S. Department of Homeland Security or ICE, and typically on forms I-200 or I-205, and do not compel institutions to cooperate and are not court orders that would under FERPA allow the disclosure of educational records without consent. A subpoena issued by a judge or magistrate allows for disclosure of a student's file, but the institution should notify the student prior to such disclosure as is required under FERPA, and the student can choose to obtain a protective order or otherwise prevent the disclosure. On the other side, an administrative subpoena is a type of subpoena that requests documents or other evidence and is issued by ICE, not a court. This impacts the timing and requirements regarding compliance, and you should consult with your in-house legal counsel or outside counsel on what to do to comply depending on the circumstances. Finally, If an ICE agent or law enforcement officer presents a judicial warrant, your institution's designated representative should review the document in consultation with in-house legal or outside counsel, and ask whether it's valid. For example, is it signed by a judge or magistrate? Does it include the address of the premises? Does it provide a time period? Does it describe the scope of the search? As you can tell, this is a very much evolving topic. We've received half a dozen questions just in the short period that I've been presenting, and I'll make sure to reach out to those folks directly. We know that this is such a moving target topic since the rescission of the guidance last week. So we tried to cover some highlights here, but please do not hesitate to reach out with questions you may have specific to your institution. And with that, I'm going to turn it over to my partner, Annie Cartwright, to discuss foreign relationships. Annie.
Thank you, Alex. I'm Annie Cartwright, and along with general education advising, I focus my practice on issues tied to, among other things, student funding and academic medical centers, including issues like foreign relationships. Here's what we expect and we know. There's a lot that we don't know, as Alex indicated, as a lot of your questions have indicated, and know that you're not alone in the uncertainty. But what we do know is that the first Trump administration pursued enforcement of Section 117 of the Higher Education Act, which had sat dormant for about 30 years before that. We would expect that to continue with interest in foreign relationships among higher education institutions in foreign countries. Note that your first report of the year for any foreign gifts and contracts totaling $250,000 or more in the aggregate in a calendar year is due tomorrow, or I'm sorry, is due on Friday. So make sure you're staying on top of that. Your institutions may have some other foreign source reporting obligations like National Science Foundation CHIPS and Science Act obligations, which are reported through an evolving NSF mechanism. For countries of concern with whom you have contracts or gifts totaling $50,000 or more. Those countries of concern are the People's Republic of China, the Democratic People's Republic of Korea, the Russian Federation, and the Islamic Republic of Iran. We may well see other obligations in foreign source reporting or inspection of foreign relationships coming through either in legislation or through executive action. Also keep in mind, export control has been a focus for some time from the executive administration, and we would expect to see some continuing enforcement, like investigations of things like the release of controlled technology to foreign national employees. So we would recommend you stay on top of those obligations as well. And then finally, as to foreign relationships, as we see signs of shifting U.S. relationships with different countries, consider the impact of those shifting relationships on your programs and consider whether you should be looking for opportunities to diversify those relationships. Let's move on to research, a topic which is keeping us on our toes. We've seen a number of developments in the last week. Most fresh on a lot of our minds was OMB Memo M2513, which was issued on January 27th and indicated plans to freeze all federal financial assistance until at least February 10th while the administration evaluated it. Yesterday, a federal judge temporarily blocked the order as to open awards. And in breaking news, thanks to members of the Crackpot team that back us up, we have been informed that through OMB Memo M2514, a 21-word memo, the executive administration has rescinded that freeze memo. So that may be a source of relief, at least temporarily for many of you. It's probably not dead altogether. So consider if you depend on grant and loan disbursements, anticipate that there may be significant delays down the road in getting your reimbursements, and prepare to argue to agencies why your funds should be exempt from any freezes. Our government contracts and nonprofit teams have issued and published some guidance around steps you can take to get ready for a freeze. We're happy to send that to you if you want to reach out to us. Looking back all the way to January 21st, we had the executive order that John mentioned on ending illegal discrimination and restoring merit-based opportunity that instructs agency heads to include in every contract or grant award a term that requires a federal contractor or grantee to certify that it does not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. We expect to see some new terms in your grants and loan and contract agreements. In terms of agency action around research, we've seen several agencies really stall in the last week, including the NIH. Some have all but ceased communication and called up a significant number of important meetings that were pending. And we would expect that to continue as the dust hopefully settles soon on how those agencies should continue to operate in the future. Aside from developments in the last week, there's certainly a possibility that Congress will push back on attempts to cut funding. There's been some talk of shifting research funding to states, and certainly talk of shifts in research priority. There is certainly an appetite for funding research around AI. There's certainly a congressional appetite for regulating AI and related privacy and security concerns. Robert F. Kennedy Jr., the nominee to be Secretary of HHS, which controls NIH, has called for a focus on some preventive medicine and alternative medicines, and taking steps to incentivize research in those areas rather than research on developing profitable drugs, which depend on continuing disease to generate those profits. And finally, there may be fewer resources to enforce the misconduct prohibitions that we've seen come to the forefront in the last few years. Let's touch on briefly nonprofit operations. The administration certainly may look to college and university funding and endowments as an area for potential recoupment of funds. There's currently an endowment tax that applies only to private institutions with endowments of reductively endowments that amount to $500,000 or more per student. There could be attempts to expand that endowment tax, and there are pending bills that attempt to do that. Where endowments are linked to both healthcare and education, expansion of the tax could certainly impact both your healthcare and education operations. So you may want to take the time to track those bills and consider planning for potential impacts. Signaling a focus on endowments was the January 21st Ending Illegal Discrimination and Restoring Merit-Based Opportunity executive order that outlined a strategic enforcement plan calling on agencies to identify up to 9 potential civil compliance investigations for large nonprofits, foundations with assets over $500 million, state and local bar and medical associations, and institutions of higher education with endowments over $1 billion. That's about 130 institutions in the United States at the moment. Beyond endowments, we may see attempts to recoup or to tax dollars earned by institutions of higher education through activities that are not traditional education or healthcare programming. Even before this month, we saw the U.S. Department of Education increase scrutiny on nonprofit status. It revised its definition of nonprofit a few years ago to say that a nonprofit is a public or private institution where no part of the net earnings benefit any private entity or natural person. And the definition notes that a nonprofit institution for purposes of Department of Education funding is not generally an institution that engages in excess benefit transactions with any natural person or entity. So it's a good time to evaluate those contracts and potential excess benefit contracts that may draw some attention. So with that, I will hand it over to Lisa to speak about accreditation.
Thank you, Annie. So accreditation is our next topic as we try to get through so many topics on this webinar today. Well, Donald Trump has said that accreditation is our secret weapon. It's not 100% clear what he meant by this, but what he may have meant is that for all of the institutions that participate in federal student aid, you have to be accredited by an accrediting agency that's recognized by the U.S. Department of Education. And so, keeping in mind the policies of the Trump administration, we may see some big changes in accreditation. For example, right now, most accreditors have standards that relate to diversity, equity, inclusion. we could see a requirement that accreditors remove those standards in order for them to continue to be recognized by the department. This is something that we're hearing a lot from clients who are concerned about DEI and are wondering, well, how do I comply with the new executive order when my accrediting agency has DEI standards that I must abide by? In those instances, we suggest that you contact your accreditor to see if you can receive guidance from them, but we may see shifts in accreditation around DEI. Although right now our political atmosphere in the US is very polarized, both the Democrats and the Republicans have long had a focus on career readiness and student outcomes. So we may see situations where our accrediting agencies now are required to have very prescriptive standards as to your student outcomes. For example, requiring that you meet a certain graduation rate or requiring that you map how a potential degree will relate to an eventual career. One of the criticisms, especially of the Republican Party of accrediting agencies, is that we've had the same accrediting agencies for a while and they lack innovation. So we may see new accrediting agencies come into being during this time period and paths that make it easier for accreditors to do more innovative type things. You may know that in Florida, there was a requirement for Florida institutions to change their accrediting agency for their public institutions. And that could potentially, if we're trying to look into the crystal ball, be a requirement that all institutions on some level at some point change who their institutional accrediting agency is. But right now, we're really doing a lot of guesswork around accreditation. But you should expect there could be some big changes on how our accrediting agencies work and operate. The last thing I'll mention is that some have thought maybe this would be a point in time where we would see accreditation be separated from federal student aid. In other words, you wouldn't need to be accredited in order to participate in the federal student aid programs. While this could happen, it seems unlikely because right now the U.S. Department of Education relies heavily on accreditors to make sure that your institutions are meeting a variety of standards in order for you to continue to participate in federal student aid. But again, this is another topic we're going to have to watch and wait and see what happens. And speaking of federal student aid, I'm now going to turn it over to my partner, Julie Maselli, who's going to talk about federal student aid.
Thank you, Lisa. Oh, I see the sun's going to join us for this webinar, and hopefully I can get through this with you all still being able to see me. So I'm one of the partners in the higher education group, Julie Maselli, who works in the Title IV regulatory space, which I find riveting, although in comparison to all these topics, which are moving more quickly, this may seem like one of the things to maybe put on the back burner. I'd encourage everybody to continue to think about Title IV compliance. I also am one of the attorneys in our group who's spent time at the U.S. Department of Education. I was there for 5 years during the Obama administration, so I've been asked to present the landscape on the Department of Education and general policy shifts. So I'm going to cover both of those topics here. The first thing I was going to cover was the late breaking news on the OMB freeze. At the time that I started this presentation, I think the pause was paused, and now the pause has been lifted entirely. Annie covered that. There is one takeaway that I may leave you with, okay, maybe two. One is that if this is resurrected in some way, as the OMB memo 15 that froze financial aid was written, it would not have covered Title IV. And that was ultimately clarified the next day by the Department of Education, but I think it's important that federal student aid disbursements and reimbursements to schools is treated a bit differently. It wouldn't have been impacted by this memo. But even though this, Annie just announced that this has been rescinded, we do think it's worth taking a look at where you are in the pipeline of receiving different kinds of financial aid that could have been impacted by this, so that if it is resurrected in any form, institutions are prepared for dealing with that. So I will go ahead and move past this topic. I know that we've all spent too many hours fretting about it, so we'll move on to anticipated Title IV related regulatory priorities. The first thing we did is really looked back at President Trump's first term. And with respect to Title IV regulation, whereas the Biden and Obama administrations really focused on detailed and nuanced rulemakings, some of which I was involved in when I was at the department, the first Trump term really focused on the opposite of deregulation. One of the first things they worked on doing was rolling back regulations on borrower defense to repayment on loans, which was an Obama era regulatory priority, and then also in repealing the gainful employment regulations. So those are just a couple of the first things that the Department of Education did under the Trump administration the first term. Based on that, and also what we can glean from Project 2025 goals, which we anticipate that this Trump administration will follow to some extent with respect to education policy, and that is a bit of a guess, but we think based on what we're hearing so far, that seems like a good guess. The deregulation activity will continue. The key areas where that will likely be focused is the new financial value transparency and the resurrected gainful employment rules. Those are currently being challenged in court, so there could be an easier path for this Trump administration to potentially roll back those rules than going through the re-regulation process. The same status is true of borrower defense to repayment. So those are two that we will watch and potentially could be rolled back in an easier fashion. Other Title IV regulatory priorities of the Biden administration that we think could either be repealed or modified through some regulatory effort by the Department of Education would be the definition of administrative capability for running a Title IV program. The Biden team raised the bar definitionally around what that meant. The financial responsibility requirements, the Biden administration expanded the department's ability there to recalculate financial responsibility scores or your composite score based on a number of circumstances, and the potential penalties that it could outline were further clarified. And also accreditation is a big Title IV related topic that Lisa covered. So that's a bit of a preview of those issues. There's also the new Biden era regulations that already became effective in July of this last year. We've discussed most of these, but I have a list for you in the slides that provides all of the regulations that became effective this past July. And these are likely, to the extent that we didn't mention, the other things that the next Trump administration may focus on. There were also a number of Biden era policies that were being pursued through the regulatory process. And I would say that at least in the immediate term, these are the sorts of things that you can put on the back burner as far as what to worry about. The pending final rules that we never saw were Biden administration proposed rules that we were expecting to see in final form on things like distance education, R2T4, or the return to Title IV calculation and process for doing that, student loan relief, and also the TRIO program. All of those pending final rules were stopped midstream with the shift of the administration, and we don't anticipate that the Trump administration will pick these up in the exact same form as the Biden administration left them. And certainly the rulemaking priorities of the last administration that were pending proposed rules, meaning we're waiting to see those, on cash management, financial hardship definitions, and state authorization are simply stopped. So for the Trump administration to take up those topics, it would be starting from scratch on those. One other area I want to cover is an incentive compensation. It was a policy statement we heard from the Biden administration. I think it's worth covering since there's a number of schools that do rely on one of the exemptions for bundled services. The Biden administration had announced that they were going to review this exception to the incentive compensation ban with respect to how schools may partner with contractors who are providing bundled services based on a tuition revenue sharing strategy, which is very common for these sorts of bundled service arrangements. We anticipated, although the Biden administration didn't say this, we anticipated that the fact that they said they were going to be looking at this meant that that exception was ripe for potentially being removed or rescinded. This is something that we anticipate the Trump administration will not pursue. So if you're a school that relies on a partner out there with bundled services agreements, we anticipate that this administration is not going to disturb that exception without a significant departure from prior policy positions. So with that, in the few minutes that we have, I'll cover a quick leadership and policy forecast. These are all our speculations. We are keeping our ears to the ground based on what we hear and our prior experience and observations of administration changes in the past. It's going to take time, but there will be anticipated a number of new faces at the U.S. Department of Education. You all know, I'm sure, that the president has already nominated for the top 2 positions, Linda McMahon for the secretary. We have some information that I'll skip over now in the interest of time. And also Dr. Penny Schwinn for the deputy secretary position. For now, Denise Carter who was was at Federal Student Aid, is going to be serving as the acting secretary until these 2 nominees that I just mentioned are confirmed. There's also a number of non-conferable political positions within the Department of Education. Historically, they have a very high number of political appointments. And as with any transition, it will take time to get those folks into the office, along with a number of deputy positions that need to be confirmed by the Senate. So during this time, while nominees are going through that process and other political appointees are being hired, we anticipate that there will be a number of key retirements of longstanding career staff at the Department of Education, as well as potential attrition of individuals even new to the Department of Education who may be considering the recently offered government buyout. There's also talk of potentially eliminating the Department of Education, which is a small government policy position that frankly has been raised periodically throughout the years since the department became an agency at the beginning of the Reagan administration. So it's not something completely new, but it's certainly, this is an idea that has more legs now with this administration. And there is a lot of talk about where parts of the Department of Education could potentially wind up. So there is some essential business to the business of higher education that would need to continue to operate in liaise with the US government. So it's not a matter of the Department of Education simply closing its doors. It's likely a matter of taking some of those essential pieces, parts, and moving them into other components of the government. So the last thing I will cover is the policy plans, again, under Project 2025 that I haven't already covered in the Title IV update. Project 2025 was disclaimed by President Trump as not something he was using as a playbook, but it is intended to identify the conservative approach to governing, and it is overlapping with a number of the statements that we hear in education policy coming out of what we heard coming out of the Trump campaign, but also now the Trump administration. It includes legislative plans for the Department of Education, as I said, a wind down of the U.S. Department of Education, moving maybe Federal Student Aid over to Treasury, Office of Post-Secondary Education over to Labor, and eliminating negotiated rulemaking requirement, which engages the sector prior to the Department of Education rulemaking. And the last, eliminating DE&I from federal education policy, which we covered earlier. With that, I'm going to go ahead and close us out. We know that there's a number of questions in the chat. If we didn't cover a key question, please reach out to your HB Education team member. And we do see a number of questions that focused in on the topic of DE&I, and we know that is a hot topic. So we will be having upcoming presentations that dig into that topic further, including upcoming civil rights and Title IX investigation trainings coming up for you as well. Thank you all for joining us today. We really hope the information was helpful to you and your organization. As a reminder, the program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be then emailed to you tomorrow, along with a recording of the webcast for watching and for sharing. Please be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business. This concludes our webinar. Thank you. Appreciate it.